Did you get the paper?
Yeah, I did.
Oh, it's okay. It's okay. Hello, my name is Joseph Pedigo, and my informative speech topic is on the Federal Witness Protection Program. The United States Federal Witness Protection Program, I have to look at y'all, is a witness protection program administered by the United States Department of Justice.
Yeah, don't bring it up.
And operated by the United States Marshal Service. That is designed to protect threatened witnesses before, during, and after a trial. The WITSEC program was formally established under Title V of the Organized Crime Control Act of 1970. WITSEC was originally created as the Federal Witness Protection Program. In the mid-1960s by Gerald Shore, who was an attorney in charge at the time of the Intelligence and Special Service Unit of the Organized Crime and Racketeering Act, section of the United States Department of Justice. Most witnesses are protected by the United States Marshal Services, while the protection of incarcerated witnesses is the duty of the Federal Bureau of Prisons. A few states, including California, Connecticut, Illinois, Texas, and Washington, D.C., have their own witness protection program for crimes not covered by a federal program. Witness protection is provided only for witnesses whose testimony is determined to be essential to the successful prosecution of a criminal case and in which the witness's life or the life of his family is at risk. The witness testimony also must be considered credible and certain in coming, meaning that the witness isn't going to back out out of giving the testimony in court. As of 2013, 8,500 witnesses and 9,900 families members have been protected by the U.S. Marshal Service since 1971. According to Gerald Shore, the person who created the federal program, about 95% of witnesses in the program are criminals. They may be intentional criminals or people who are doing business with criminals, such as one engineer who bought off a mayor because that's how you do business in the city. In his mind, he wasn't doing anything criminal, as Shore said. A witness who agrees to testify for the prosecution is generally eligible to join the program, which is entirely voluntary. Witnesses are permitted to leave the program and return to their original identities at any time, although it's always discouraged by the administrators. In both criminal and civil matters involving protected witnesses, the U.S. Marshals cooperate fully with local law enforcement and court authorities to bring witnesses to justice or to have them fulfill their legal responsibility. Less than 17% of protected witnesses who committed a crime will be caught committing another crime, compared to almost 41% of parolees who return to crime. The U.S. Attorney General's Office, which has final word on all witness protection cases, has defined specific cases in which witnesses may be granted entry into the witness security program, including any offense defined in Title 18, United States Code Section 19611, which covers organized crime, and racketeering. Any drug trafficking offense described in Title 21 United States Code 1961. Any other serious federal felony for which a witness may provide testimony that any subject the witness to retaliation for violence or threats of violence. Any state offense that is similar in nature to those set forth above. Certain civil and administrative proceedings in which testimony given by a witness may place the safety of that witness in jeopardy. There have been some corrupt federal agents, but the one I found was about a former decorated federal law enforcement officer, John Thomas Ambrose, who was convicted of leaking information about a federal witness in the protection program. Chicago outfit hitman Nicholas Calabrese to other members of the Chicago organized crime.